My name is Millicent, and today I'm going to be presenting on the concept of Estoppel. Have you ever been scammed or defrauded? Well, I have a few times. Oftentimes, people transact with one another. As they're transacting, information is transferred from one party to the other. And sometimes, one of the parties might just decide that they're going to give you false information so that they can gain an advantage over you. Let me give you this example. Let's say you're buying weight loss pills from somebody and they promise you that it's going to give you weight loss within 30 days or else they're going to refund you your money. This is their money back guarantee. 30 days down the line, you don't lose any weight. And when you ask for a refund, they tell you that no, actually, you'll need 3 years to lose weight when you're on this product. Fortunately, there's a legal remedy that you can actually apply called estoppel. Estoppel is a concept where when one person has misrepresented the facts to you and you act based on those facts, but it actually turns out to be to your detriment, you can then ask the court to stop that person from actually claiming the true facts of the matter. It is called estoppel because it comes from the word estop. That means to stop somebody from doing something. Estoppel has a number of requirements for it to be successful in the courts. Number one, there must be a misrepresentation. Number two, it requires fault. Number three, causation. Number four, there has to be prejudice. And also, there must be legality. We're going to break these down. So in this discussion, we are defining estoppel. We're also defining the requirements, the limitations, and also in which situations it actually applies. Misrepresentation is defined as any act or any words that any person will say to you or will act towards you or with you when you are transacting, but also it can be an omission. An omission is silence, or in a case where somebody is expected to act and they decide not to act, that in law is perceived as an omission. So misrepresentation comes in it requires two aspects. There must be an act, or somebody must say something, or it must be a silence or lack of action from someone. But then that alone is not sufficient. There must be a false statement for it to be a misrepresentation. If it's just an opinion, it doesn't count. If somebody says something that is not of fact, it will not count either. It has to be something that is of fact, not necessarily something that will happen in the far future. It must be something that seems to be facts that are correct at that point. But in this case, for it to be misrepresentation, it must be false. If a person represents something that is false to you, and based on that information, you then act, and that act leads to your detriment or to your disadvantage, you have a right to claim estoppel. If you do not have all those facts correctly, you cannot rely on estoppel. There are some cases that have been cited to support this case. There was a lady that actually said that she would be surety, she would stand surety for her brother. She told the creditors that she would be able to stand surety for the brother because the brother owed her a lot of money, much more than what the brother owed them. So they allowed the surety. When time came for them to actually ask her to make the payment for the brother, she then decided that she couldn't anymore. And she wanted to use the estoppel remedy to block them from claiming the money from her. And the courts did not allow it because she misrepresented the facts to them. Therefore, she had to be upheld to the agreement that she will stand surety for her brothers. In a number of cases, you find that an agent acts on behalf of another person, the principal. If the agent decides that they're going to do something outside of the agreement, they cannot expect the principal to uphold the agreement. In another case, The principal requested an agent to keep horses for him while he was going away. He didn't ask him to sell them or to advertise them. He asked him that he must look after his horses while he is away. The agent's mandate at that point was only to look after the horses. But then the agent decided to sell them. When the owner returned, he realized that the agent had sold these horses, and he used a remedy called the re vindicatio. Re vindicatio is a remedy that somebody can use to claim back what is theirs. In Roman law, there's another concept called where I see my thing, I claim it. That means if, for instance, you have an article or a product that went missing, and at some point you come across it, you have every right to claim it. This was supported in a case of an auction. A farmer had lost his cow a number of years prior, and then he spotted it at an auction because it was marked. But in this case, the owner did not claim it. He allowed the auction to continue. After the auction, he decided that he was going to the new owner to claim his cow back. The court decided that because he was there at the auction and he saw that his cow was being sold and he kept quiet and didn't say anything, he cannot now claim it. This is where the concept of omission comes in. If the person should speak and they decide to keep quiet at that point, they cannot come back and claim the thing. Because the moment that they see it, they have a right to claim it. When he saw it at the auction, he should have spoken up. He should have said he objects to the sale. Then he would have been able to claim his cow back with the re vindicatio. In cases of re vindicatio, it is possible to use the Estoppel concept, provided all the elements that are required are there. There's another concept where it states that movables cannot be pursued. So the elements there must be relevant elements for the concept of Estoppel to actually be successful. If there's a representation, if it's a false representation, or if it's an omission, that is the first fulfillment that is required of misrepresentation. But then it doesn't stop there. We're going to tie in now with the law of dialect in the form of fault. But with the concept of Estoppel, it is not treated exactly the same as it is in dialect. When it comes to fault, in the Estoppel concept, only negligence, which is culpa, is required. Because fault comes in two forms. It's either intent, which is dolus, or it is negligence, which is the culpa. In South African law, it has been established that regarding Estoppel, when it comes to fault, intent is not required. You do not have to prove intent. All you need to prove is that the person was negligent in their behavior. Only the culpa is required. What exactly would the negligence be? Negligence is defined as where a person can see that the other party will most likely lose or they will gain an obligation that they actually do not need. But instead of preventing the loss or the new obligation, and they allow that person to actually go through with the process that is actually to their detriment. In that case, the person that has done the representation is the deceiver. He would be or she would be the Estoppel denier, because Estoppel will be claimed by the person that has been disadvantaged. That person is identified as the Estoppel assetter. If you're doing a representation to a party and you can see that this representation is going to harm the other party and you do not prevent it, it is said that you have acted negligently because you could foresee the harm that was coming. But it also doesn't end there. It requires a test, and this test is based on what would a reasonable person in the same circumstances have done? If the estoppel assertor behaved in a way that a reasonable person would have done, then you cannot claim negligence on the part of the estoppel assertor, because that would be something that any other person would have done as well under the circumstances. It is also said that there mustn't be any ambiguity, and ambiguity is when something is not clear. It could have more than one meaning. But if something is clear and precise and it only has one meaning, then it should not deceive the other person. But if that statement has deceived the other person and there was ambiguity, it can therefore be argued that it could have meant two different or three different things. So for it to be qualified as a misrepresentation that led to the other party's detriment, and that could have been prevented, there shouldn't have been more than one meaning to it. Now we move on to prejudice. There has to be prejudice that the estoppel assertor will actually suffer. This is not prejudice that is based on race or gender or anything like that. It has to be patrimonial loss, patrimonial prejudice. So this person would have suffered in a way that causes them to be in a worse off position. And that is the test here. They will look at what position is the person in now. If the estoppel assertor is in a worse off position than they would have been had it not been for the misrepresentation, then there's been prejudice. If, for instance, the estoppel assertor loses money, for instance, there's a reduction in their assets as a direct result of the misrepresentation, they would then be in a worse off position, wouldn't you say? But if it does occur that because of the misrepresentation, the estoppel denier, the estoppel assertor is actually in a better off position, then there is no prejudice. Prejudice means the estoppel assertor is in a worse off position. Moving from prejudice, there's also a requirement for a direct link, a causation. The behavior of the estoppel denier must be the direct cause, or it must have most likely been the direct cause, or have induced the actions of the estoppel assertor. Let's say, for instance, the estoppel assertor would not have acted had it not been for the misrepresentation. If the misrepresentation comes in and it causes the estoppel assertor to behave in a certain way, or it modifies their behavior, for instance, they decide that they're going to enter into this contract. Maybe because the estoppel denier has presented a contract that looks very lucrative, that looks very profitable, and it's attractive and appealing for them. The estoppel assertor might just decide to take the contract up, but only then later realize that it was all very faulty and there is no benefit to the contract. Then that means that the estoppel assertor is now left in a worse off position, and there is a direct link due to the misrepresentation. Now we meet these four elements. We've got now a misrepresentation, which is false, and it is prejudicing the estoppel assertor. Now the fourth element of causation means that all those actions must be a direct cause that led to the disadvantage on the side of the estoppel assertor. There is a test, and they call it a proximity cause. This means that the closeness of the two events must be very, very close. It mustn't be far off. It mustn't be remote. There is a case that occurred where a post office employee was asked by another post office employee to use their office on a Sunday. And the first employee allowed the second employee to use it on a Sunday. He said that he needed to get some extra work done because he didn't get to it during the week. So on the Sunday, well, he actually asked for a number of Sundays. On one Sunday, he found the post office stamp that was in the office of that other employee. He used the opportunity to stamp false documents that came from 3 years prior. These were documents or post office orders that were going to be issued to the bank or submitted to the bank for payouts of money. When the bank realized that they had received false orders, that actually they had already issued the money based on false documents, they then wanted to claim the money back. And as they were applying to claim the money back or using their right to use the re vindicatio, then a person that works at the bank, at the post office, indicated that he did not intend for all of that to happen. And the court actually decided that there was no direct cause between the first employee allowing the second employee to use the office. That could not be the direct link, although he was negligent in his behavior because he didn't hide away the stamp. It could not be said that it was a direct link. However, the link was between the other employee who stole the post office orders and actually submitted it to the bank and the bank releasing that money. So it has to be clear where the link has occurred. When there's a third person, you cannot blame the third party as the event that caused the misconception or that caused the disadvantage. It has to come directly from the person that interacted with the other. For instance, where there is an agent, where the agent has authority, it has to be determined how much authority they have. For instance, an agent is called the mandus, and the principal is the mandataris. He will be the one that gives the mandate to the agent. The agent is the one that receives the mandate and has to carry out the actions. If the agent's mandate is to sell a property and it is specified that they must sell a specific property, that's where the mandate stops. He cannot now sell the properties next to it as well. He cannot sell more than what he's been mandated to do. He can only act within the mandate that he has received. So there must be authority for the agent to act on behalf of a principal, and there must be an indication of what the extent of the agent is for him to act for the principal. If he acts outside of the mandate, the principal cannot be held liable. There was a case where an agent was selling horses for a farmer. He was given a number of horses, and there was a mandate that stipulated how much he could sell. Upon seeing that there was a purchaser that seemed to have a lot of money, he decided to lie to this purchaser. He told the purchaser that he could sell much more, and that extra amount was told to him verbally. It was not stated in the mandate. It was told to him verbally. And now the purchaser decided to buy more horses. When the owner found out, when the principal found out, he claimed his horses back because the mandate had stipulated the extent through which the agent could actually act. And the court did not allow the estoppel that was claimed by the purchaser. Instead, they did allow the re vindicatio to proceed by denying the estoppel. The last point or requirement for the concept of estoppel, legal remedy of estoppel, is that whatever it is that you are asking for, it must be legal. Because now a person needs a remedy. The remedy that you seek, the estoppel that you seek, must be legal. In terms of there mustn't be a prohibition. For instance, if it's something that would lead to legal activity that you are asking for from the court, they cannot grant it. If you're asking to claim back money from activities that are illegal, you cannot claim it back, or that will result in illegal activities happening. That cannot be allowed. For instance, in the government offices, as we would know, well, most of them, they're so slow in their work that we might miss this, but if they're working efficiently, you might find that you are asking them to do something that they cannot do. It has to be something that is legal. For instance, an application for a license. Let's say it's a trading license, as it has happened in one case. What happened is the response that went to the applicant was actually a successful application notification, which was actually supposed to be a rejection. There was an error that was made by that office. They included the name of that applicant in the list of approvals that they had to issue. They only found out later that they actually meant to reject that particular application. When the applicant found that they revoked the license because it was entered erroneously, they then applied for the Estoppel. And the court decided that they had the authorizing body had a legal reason why they were not going to grant the applicant the license. Therefore, if they now uphold the false statement, it would become an illegal activity, because that would mean they must now forego the requirements that had to be met that were not met by the applicant. In another example, it will be where a minor enters into a contract. For instance, let's say this minor, as teenagers most likely would do, they like to present falsehoods. In this case, this minor says that they are old enough to enter into a contract by themselves without parental guidance or approval. Now, if you don't check your facts and you enter into this contract and later find out that the person you contracted with is a minor, you will not be able to uphold the contract, because the minor cannot now be given a status of being a major, because the law cannot now change the fact that he is a minor. And they cannot allow the contract to be upheld, because that would be illegal. So in this case, the minor would not be able to get back their performance, but there would be a remedy. There would be a remedy that would be dialectual damages. If you have already performed, you would be able to use dialectual damages as well in order to be able to retrieve or recover some of the performance that has already been done. So wherever a legal status or capacity is required to be addressed, it has to be considered whether it's something that is legal or not to do. Estoppel cannot override statutory prohibition or legislation. It has to align with what is allowed, not only public interest, but what is allowed by legislation to be done. Estoppel as a remedy is important to give in contracts that are not covered by contract law and law of dialect, because it can give remedy. And in most cases, wherever there's been a wrongful doing, there must be a legal remedy. However, you have to ensure that you meet the minimum requirements or the requirements listed and mentioned herein, because as indicated, there are limitations, especially when it comes to legality, in terms of when and how the Estoppel can be used. It will not apply to every single situation. According to the Constitution, they advise that when it comes to the matter of having power or being able to use your power within reasonable authority and not acting ultra vires, because in some cases, there are people that abuse their power, but that is not allowed by law. It has to be checked, or it has to be studied according to every single case in terms of what is the disadvantage, what is the detriment that the other party has suffered. However, legality stands. It is important for the Estoppel to be upheld, legal consideration has to be done. Thank you.
So thank you so much, Millie. I believe it is a nice presentation and all the points that you covered so transparent that hardly any question came in mind. However, there are certain points that I would like to understand. The term you used, basically the maxim, the Roman maxim you use. What was that? When I see, I have right to claim. Something like that.
Yes, okay, I would like to give you the actual Roman pronunciation that actually disappeared. It skipped my mind a little bit. It's ubi meum rem invenio ibi vindico, which means where I find my thing, I claim it.
Is it Roman or Latin?
According to my material, it's Roman.
Okay, okay, okay. So, what I want to understand from this maxim, uh, well, there is no limitation. Means it's happened to be many years, but there is no limitation can be claimed any point in time.
Yes, I would like to go back to the case of the cow that had been missing for 5 years. So this was identified at an auction. So I can imagine at this point the owner had lost hope and given up and believed that it was gone. But obviously because it's been marked in a certain way, he was able to identify it. So the issue here is that he did not speak up and claim it at that point. So again, this would tie in with this maxim that says, where I find my thing, I claim it. You don't leave it until later to say, okay, but I saw this last month, so now I'm going to go and claim it. That means that when you see it, you must now speak up. It's your opportunity to speak up now and say, I object. This is mine, and I'd like to claim it back. Because by keeping quiet, it means that you are allowing for the sale to continue. So this is where the omission part matters. Because if you have a responsibility to speak up and you keep quiet, then there is an omission on your part.
Okay, but in that case, Milit, the question is in that case, see, who is going to prove when I have seen that, when I recognize that that is mine, right? So,
Yes,
well, I have seen that certain point in time, maybe around in auction, you as you told. In auction, I have seen that, but I took time to recognize that that is mine. So by the time the cow is already sold, right?
yes.
So in that
And
case, what will happen? Court will consider his this time period.
I think it depends on the circumstances of the case. In this particular case, it was mentioned that because he didn't claim it at that point, that he could not now claim it later because the purchase has occurred. So I suppose what is required here is that you speak up right away. I don't know if
Well,
auctions would allow that, but you have to speak up right away. Say, no, this is mine.
yeah, that is true. But the fact is, until unless you get confirmed, okay, that is exactly yours. Maybe a similar kind of thing possible. There could be similar kind of objects or it's not something a big
Yes,
deal, right? So
yes,
until unless
yes,
I verify that my dot, I verify it, okay, as you said, the another term you said, it has to be the last point you said, it has to be legal, isn't it?
yes,
So
yes.
claiming someone else property mine, that is not fair, no?
No, you can't just go and claim it like that on your own. You have to then request the application. I suppose in real life situations or in situations now, the best thing is to say to the other party that I believe this is mine. I would like to confirm if I'm not sure about the facts and try to have a discussion about it. And perhaps if the other party insists that they don't accept whatever proof that you adduce, then you can look at taking the litigation part. Because again, you want to consider that there is a possibility that you could be mistaken, like you're saying. What if you still need clarity in confirming that it really is your property? So you might not necessarily know right away, but perhaps to speak up about it at that time, to say, this is what has happened, and I think this is my property. I'd like to look into it and to confirm it. If you can allow me and allow a discussion to happen, that could maybe be a solution. And possibly, if the other party is amenable to understanding your situation and allowing you to prove it, maybe then you can even avoid litigation. Because then what would happen in that case, the other party will have to claim their money from the auctioneer, not from you, because now the auctioneer has to confirm where did they get that property. If they've also bought it from someone else, then they must go claim it from that party. So you wouldn't have to give the other party the money. So you don't have anything to lose by having a conversation with them. But then they must now know that if it's something that can be confirmed that it did not belong to the person that was selling it, then they must know how to then remedy that situation and get the money back from the party that was wrong. Because sometimes it can be a car. There's a case where a car was sold. The person that bought it did not have cash on him when he was buying it. And then he said his checkbook was in another town. So the owner of the car said, I'll go with you. You can get your checkbook and write me out the check. And then I'll transfer ownership of the vehicle to you once I've received the money. They went together. He wrote out the check and gave it to the seller. Only finding out later, the seller realized there was no money. He couldn't withdraw any money with it. It was not a valid check. But in the process, or in the meantime, the other party sold the car to a third party. And then the owner then went to court and claimed with the re vindicatio, because ownership had actually not been transferred, because it was dependent on the transfer of the money happening. So now there was no money. He delivered, but then he didn't receive the money. So the court allowed him to claim back the car because the transfer of ownership had actually not occurred. So the person that bought the car had to then claim from the second seller. So it is a situation that can happen sometimes, and sometimes people can make sales without you knowing about it. There are cases of hire purchase agreements where a person has to pay off in installments, and ownership is only transferred after full payment has been received. But then the goods are transferred to them immediately. In that case, the person that has received possession is still not the owner, because he will only become the owner only once the full payment is made. And in that case, even if they sell the product or the object to someone else, that person will never be a bona fide owner, because ownership has actually not been transferred. So then that property can still be claimed back by the original owner. In South Africa, and also it stipulates there that in English law as well, intent is not required at all. It's irrelevant when it comes to estoppel. It's relevant in dialect, but with estoppel, it's irrelevant. So what is also indicated is that it depends also on the cases that are before the court, because in most cases, it has been indicated that negligence is a requirement. However, that is still open to debate. There could still be a case where the other elements are sufficient and negligence is not necessarily required. So there's still some development that can be done regarding that part. But negligence at this point, in the decided cases, it has come up that it is a requirement.